My name is Ruth Schaefer, and Levi is my son. Due to the conduct of the police after killing Levi, I will never trust their account of how and why my son died. After Levi's death, I found that there exists no legal obligation for the police to follow their own regulations. There are no consequences for willfully ignoring them. I decided to launch this legal battle not for Levi, for whom it is far too late, but for my grandchildren and all the other children who will grow up in Ontario. If the courts and the public allow this standard of police impunity, we risk falling into a state of fascism.
The coalition Justice for Levi proudly presents...
We want justice for our communities, not police impunity.
Or, why won't the police just write their notes according to the law? Police are supposed to serve and protect. They have special duties as public servants. They also have special powers, like the right to use force, even lethal force, against the public. A high level of accountability and transparency is necessary from police in order to hold public confidence in their role in the administration of justice. On June 22, 2009, a 30-year-old schizophrenic man from Peterborough, Ontario was shot dead by an Ontario provincial police officer on a secluded peninsula near Pickle Lake, Ontario. His name was Levi Schaefer. 2 days earlier, in a separate incident, a man named Douglas Minty was killed by an Ontario provincial police officer outside of his Elmvale, Ontario home, while his elderly mother watched. After each of these killings, Ontario's Special Investigations Unit contacted the families of the dead and explained that it was their mandate to investigate when police actions cause severe injury or death and to determine if police are criminally responsible. The Special Investigations Unit was created in 1990 as a response to the public call to end the practice of police investigating police. The S.I.U. was created to provide clear civilian oversight over investigations involving citizen injury or death and the police. It is the law in Ontario that police comply with S.I.U. investigations. Officers whose actions have led directly to harm or death are called subject officers by the S.I.U. They don't have to give an interview to the S.I.U., but they do have to provide their notes. Officers who are not designated as subject officers but are in some way involved in an S.I.U. investigation are called witness officers. They have to submit to an interview by the S.I.U. and they have to hand over their police notes. Special Investigations Unit investigators review the interviews and police notes to determine whether there is sufficient evidence to find that an officer or officers may have committed a criminal offense in the harming or killing of a member of the public. Police notes are particularly important. Police use their notes in court to refresh their memories and to provide their independent and contemporaneous recollections of an incident in order to provide the courts with trustworthy evidence and testimony. In the case of Levi Schaefer, S.I.U. investigators gave their report to the director of the S.I.U., who then submitted a report to the Attorney General of Ontario. The director found no officers criminally responsible for Levi's death, but said, very publicly, that in this important case there was no reliable, trustworthy evidence from which to investigate. In Levi's case, only the officer who shot Levi and his partner that day directly witnessed what happened. When they returned to the mainland, their supervisors told them not to write their notes until after they had spoken to an Ontario Provincial Police Association lawyer. The law is clear: an officer must complete their notebook by the end of their shift. The officers in this case completed their notes 2 days after the incident, and only after speaking to the same OPPA lawyer. This lawyer represented every single officer in any way involved in the Schaefer case. Oddly, this same lawyer represented every single officer in the Minty case. A very public dispute erupted in 2009 between the director of the S.I.U. and the then commissioner of the OPP, quite specifically about the untrustworthy police notes and the consequences on S.I.U. investigations. On November 4th, 2009, the Schaefer and the Minty families filed an application and asked the courts for a judicial interpretation of the law to see if joint lawyer retainers by subject and witness officers and the OPP note-taking behavior was or was not permitted by law. The night before the matters went to court, the Office of the Attorney General of Ontario pulled their legal counsel from representing the S.I.U. director. The S.I.U. director soon got his own lawyer and declared support for the Schaefer-Minty application. In January 2010, the broken relationship between the S.I.U. and the police became so public and so tense that the Attorney General asked a judge, Mr. Justice Patrick Lesage, to look into the troubles and to make recommendations to him. Justice Lesage's process was private and closed and included no feedback from families, affected communities, or the general public. At Ontario Superior Court, lawyers for the OPPA put forward a motion to strike the family's application. They argued that the families had neither private nor public interest standing and that the matters were not justiciable. Or, in other words, that these were political legislative matters and not matters to be dealt with in a court of law. In a June 23, 2010 decision, the judge found in the OPPA's favor. Ontario Provincial Police then asked the court to award them costs, asking for $92,000 from the families who have brought their policies and procedures to question in a court of law. Thankfully, the court did not reward the OPPA costs. The families already had such big legal bills. In early September 2011, the Schaefer and Minty families took the Ontario Superior Court decision to the Ontario Superior Court of Appeal. Their lawyers effectively argued that the families should be granted public interest standing. The lawyer for the S.I.U. director supported the family's appeal and also effectively argued for public interest standing. In court, many parties sought intervenor status. Supportive of the family's appeal were counsel for the S.I.U. director, the Criminal Lawyers Association, the Urban Alliance on Race Relations, and the Canadian Civil Liberties Association. Many police interests also sought intervenor status. Lawyers for the family asked the panel to decide the status issue and also to hear and decide on the original application. A three-party panel of Ontario's top judges heard arguments over 2 days. They decided that since new legislation implemented by the Attorney General following a recommendation in the Lesage report now prohibited joint retainer of the same lawyer by subject and witness officers, that matter was moot. They granted the parties public interest standing and decided that the little big question of police notes was in no way resolved or moot. The judges agreed that the matters before the court were absolutely justiciable. OPPA lawyers argued that this panel of judges did not have the jurisdiction to make a ruling regarding the original application. The judges declared that they did have jurisdiction to decide on these matters. On November 15, 2011, the Ontario Superior Court of Appeal released its decision. The court stated that, quote, "The concern is that seeking legal advice is geared to the officer's own self-interest or the interests of fellow officers, rather than the officer's overriding public duty," unquote. Notes wouldn't be a straightforward recollection of what happened, the court stated, but would reflect the lawyer's advice. The court decision was enthusiastically supported by the S.I.U. The decision made by the Ontario Superior Court of Appeal made it clear that police officers could and should speak to their lawyers to solicit basic legal advice, but that advice should not influence the content of their notes which must be completed by the end of their shifts, regardless of whether they have talked with their lawyer or not. This would ensure police notes are always independently written and contemporaneous and could be trustworthy evidence for use in an S.I.U. investigation. Finally, the Schaefer and Minty families their communities, and their lawyers celebrated the victory in the courts. It meant that people who lost someone that they loved to police action wouldn't have to go through the secondary grievance of an unaccountable, untrustworthy investigation, which is further muddied by questionable notes. Finally, this decision would hold officers to completing their notes by the end of their shifts and to writing the content of their notes independently without content input from a lawyer. There can be no justice for the dead, but this was the first taste of justice for the Schaefer and Minty families since the untimely death of their loved ones. In December 2011, the Office of the Ombudsman of Ontario released a report called Oversight Undermined, in which the Schaefer-Minty case is discussed at great length as an example of the grievous systemic problems festering between police forces, police interests, civilian oversight bodies, governing ministries, legal professionals, and the rights and interests of the public. The report decries the Ministry of the Attorney General's Office for protecting the interests of police over those of the S.I.U. or the public. In the report, the Ombudsman declares that the police refused to cooperate with the S.I.U. in over 1/3 of the cases that fell under S.I.U. mandate. Everything seemed settled until mid-January 2012, when the OPPA interests filed for a leave of appeal from the decision made by Ontario's top court to the Supreme Court of Canada. Outraged by the absurdity of such a long journey, frustrated that police won't just follow the law, and still mourning their loved ones, the families and communities of Douglas Minty and Levi Schaefer now prepare to see this case to the end at Canada's top court. Despite clearly identified internal governmental conflicts that have plagued the public's right to police accountability, despite an atmosphere where government bodies related and work through legislation are unwilling or unable to work to accomplish what is mandated of them, and despite the unlimited budget that the state can access to address these deep problems, it has been left to the efforts and pocketbooks of 2 Ontario families to insist, in the interest of the public, that festering systemic problems of impunity and lacking police accountability be addressed once and for all. At the Superior Court of Appeal, many police interests sought intervenor status into this case. Many more are now expected to seek intervenor status as the Schaefers, the Mintys, and their lawyers, Julian Falconer and Sunil S. Matai, prepare to meet the force of not only Ontario's, but Canada's police interests at the Supreme Court of Canada. There is no set date, but if and when the Supreme Court accepts to hear the appeal put forward by the OPP, it is expected that the matter will come before Canada's highest court in December 2012. Ominous, eh? And what about justice? Will the police have to follow the law and finish their notes on time and independently? Will young Canadians grow up in a world with an unaccountable, unrestrained, and unfettered police force capable of even killing without ever having to give true and complete evidence to the courts, oversight bodies, or the public? Will the Canadian public awaken and acknowledge and mobilize to organize, to educate, and to take collaborative action to meet a rising tide of police impunity with resistance? The end? To find out, stay tuned. Is this the beginning of the end for a public's right to just, trustworthy, and accountable policing? Or is this just the beginning of the end of an age of police impunity?
Thank you. Contact the Coalition Justice for Levi. info@justiceforlevi.org. Learn more, www.justiceforlevi.org, www.fcbarristers.com.